of contrary opinion say nay. The ayes have it.
Clauses 9, 10, 11, 12, 13, 14, 15, 16, and 17.
I propose the question that clause 9, 10, 11, 12, 13, 14, 15, and 16 be part of the bill. There be now amendment. I now put the question that clauses 9, 10, 11, 12, 13, 14, 15, 16 be part of the bill. Will as many as have that opinion say aye? Will as many as have a contrary opinion say nay? The ayes have it.
Clause 17.
I propose the question that clause 17 be part of the bill. Chairman.
Madam Chair, I propose that this clause 17 be amended the way it appears on the order paper. And the justification for this, Madam Chair, is that the bill is amended to provide an additional feature of technopolises to incorporate not just national, but also global challenges that may appear. And I want to give a little credit to the member, Farah, who is also sitting in the presidium, for noting that technopolises exist as Technopolis, if it is one, and technopoli and technopolises in majority. Thank you very much, Madam Chair.
Honorable Farah Maalim. Honorable Maalim. Honorable Maalim.
I concur and I support the chair in this amendment. Thank you.
I now propose the question that clause 17 be amended as proposed by the chair. Honorable Undo.
Chair, I support, the jargons being used are so high sounding, they are scary. Please come back down to where we are, but I support.
I put the question. I now put the question that clause 17 be amended as proposed by the chair. Will as many as have that opinion say aye? Will as many as have a contrary opinion say nay? The ayes have it. I now put the question that clause 17 as amended be part of the bill. Will as many as have that opinion say aye? Will as many as have a contrary opinion say nay? The ayes have it.
Clauses 18, 19, 20, 21, 22, and 23.
I propose the question that clauses 18, 19, 20, 21, 22, and 23 be part of the bill, and there be no amendment. I now put the question. On 21. Honorable Chair, that will come later. I now put the question that clauses 18, 19, 20, 21, 22, and 23 be part of the bill. Will as many as have that opinion say aye? Will as many as have a contrary opinion say nay? The ayes have it.
Clause 24.
I propose the question that clause 24 be part of the bill. Chair.
Madam Chair, my proposal is that clause 24 be amended as it is appearing on the order paper. And this is so that the proposed subclause is provided for to enhance the substantive and procedure of due process that seeks to require the authority to notify an applicant of any refusal to issue a permit. Madam Chair, I move.
Thank you, Chair. I propose the question that clause 24 be amended as proposed by the chairman. I now put the question that clause 24 be amended as proposed by the chair. Will as many as have that opinion say aye? Will as many as have a contrary opinion say nay? The ayes have it. I now put the question that clause 24 as amended be part of the bill. Will as many as have that opinion say aye? Will as many as have a contrary opinion say nay? The ayes have it.
Clauses 25, 26, 27, 28, 29, 30, 31, 32, and 33.
I propose the question that clause 25, 26, 27, 28, 29, 30, 31, 32, and 33 be part of the bill. There be no amendments. I now put the question that clauses 25, 26, 27, 28, 29, 30, 31, 32, 33 be part of the bill. Will as many as have that opinion say aye? Will as many as have a contrary opinion say nay? The ayes have it.
Clause 34.
I propose the question that clause 34 be part of the bill. Chair. Honorable KJ.
Madam Chair, I move that clause 34 be amended as is appearing on the order paper. And Madam Chair, the undue flexibility that had been given earlier to the authority may be subject to abuse because paragraph E, as had been drafted in the bill, was giving authority the power to set out such further information as the authority may consider necessary. And we thought this could be subject to abuse. So we are amending it as is appearing on the order paper, Madam Chair. I move.
Thank you, Chair. I propose the question that clause 34 be amended as proposed by the Chair. I now put the question that clause 34 be amended as proposed by the Chair. Will as many as have that opinion say aye? Will as many as have a contrary opinion say nay? The ayes have it. I now put the question that clause 34 as amended be part of the bill. Will as many as have that opinion say aye? Will as many as have a contrary opinion say nay? The ayes have it.
Clause 35.
I propose the question that clause 35 be part of the bill, Chairman.
Thank you very much, Madam Chair. And my proposal is that clause 35 be amended as is appearing on the order paper. Madam Chair, I'm just waiting for a clearance on this. I'm depending on my tab here, so let me use this one. Madam Chair, it is my proposal that we amend clause 35 as is appearing on the order paper. And why we are doing this, Madam Chair, is because the review and appeal clause provides an internal dispute resolution mechanism of the first instance before the aggrieved parties elect to go to the courts of law. Madam Chair, I move.
Thank you. I propose the question that clause 35 be amended as proposed by the Chair. Honorable Professor Undo.
Chair, please, you see, when you delete the clause 35 in entirety and replace it in what you have provided here, yet in the bill, clause 35 had two parts, and part 2 provided for the timelines in which to make the decision. Are there any internal mechanism to ensure, as it has been contemplated here, that that review is made and communicated to the applicant within 30 days of receipt of the request? Thank you, Chair.
Chairman. Honorable KJ.
Madam Chair, we can retain the timelines, but provide for this remedy, Madam Chair, so that what we are doing is getting rid of of 35.1 is what we are replacing with the amendment, and then we are able to retain 2 so that we keep the timelines as within 30 days of receipt of request. And thank you very much, Daktari.
You may
Madam Chair, allow me to take this again.
You may proceed.
With a fine rereading, and I would want to ask Professor Undo to work with me here. The provisions that we are giving is for an internal mechanism of dispute resolution that will in itself take care of the timelines, Dr. Undo. So kindly let's delete 35 and replace it with the amendment as appears on the order paper.
Now I now put the question that clause 35 be amended as proposed by the Chair. Will as many as are of that opinion say aye? Will as many as have a contrary opinion say nay? The ayes have it. I now put the question that clause 35 as amended be part of the bill. Will as many as have that opinion say aye? Will as many as have a contrary opinion say nay? The ayes have it.
Clauses 36 and 37.
I propose the question that clause 36 and 37 be part of the bill, and there be no amendment. I now put the question that clause 36 and 37 be part of the bill. Will as many as have that opinion say aye? Will as many as have a contrary opinion say nay? The ayes have it.
Clause 38.
I propose the question that clause 38 be part of the bill, Chairman.
Madam Chair, it is my proposal that clause 38 be amended as it is appearing on the order paper. This proposed amendment provides a useful sanction in restricting an activity as an enforcement measure for violation, which may have been inadvertently omitted in the bill. Madam Chair, I do move.
Thank you, Chair. I propose the question that clause 38 be amended as proposed by the Chair. I now put the question that clause 8 be amended as proposed by the Chair. Will as many as have that opinion say aye? Aye. Will as many as have a contrary opinion say nay? The ayes have it. I now put the question that clause 38 as amended be part of the bill. Will as many as have that opinion say aye? Will as many as have a contrary opinion say nay? The ayes have it.
The next one. Clauses 39, 40, 41, 42, 43, 44, 45, 46, 47, 48, 49, 50, 51, 52, 53, 54, 55, 56, 57, 58, 59, 60, and 61.
Thank you. I propose the question that clauses 39 to 61 be part of the bill. And there be no amendment, I now put the question that clauses 39 to 61 be part of the bill. Will as many as have that opinion say aye? Will as many as have a contrary opinion say nay? The ayes have it.
Clause 62.
I propose the question that clause 62 be part of the bill. Chairman?
Madam Chair, allow me to move that clause 62 be amended as it appearing on the order paper. And the proposed amendment is seeking to clarify that the subclauses 1 and 2 are distinct and severable in terms of providing for the incentives that extend to the Technopolis. I move, Madam Chair.
Thank you, Chair. I propose the question that clause 2 be amended as proposed by the chairman. Honorable Wilberforce Oundo. Honorable Silvana Sosoro. Honorable Mishimboko, Commissioner. Thank you. I now put the question that clause 62 be amended as proposed by the chair. Will as many as have that opinion say aye? Will as many as have contrary opinion say nay? The ayes have it. I now put the question that clause 62 as amended be part of the bill. Will as many as have that opinion say aye? Will as many as have a contrary opinion say nay? The ayes have it.
Clause 63.
I propose the question that clause 63 be part of the bill. And there be no amendment, I now put the question that clause 63 be part of the bill. Will as many as have that opinion say aye? Will as many as have a contrary opinion say nay? The ayes have it.
Clause 64.
I propose the question that clause 64 be part of the bill. Chairman, you have an amendment.
Madam Chair, I'm seeking to delete clause 64. And the reason why I'm seeking to delete clause 64 is that we find it unnecessary. This is because all the penalties have been provided for in the specific provisions of the bill where an offense has been created. Madam Chair, I do move.
Thank you. I propose the question that clause 64 be deleted as proposed by the chair. Yes, Honorable Professor.
Probably Chair needs to be a bit careful here. As much as you are very thorough and detailed in legislation, there will be an offense that will be forgotten, will be an offense that will be provided for any part of the bill that no specific fine or sanction is provided for, and that's why it's normally a general practice to put there a general penalty clause to cover any eventualities or any unknowns. I just beg we rethink about it, so that we do not have a situation where we pick something has happened and we have no recourse. Thank you, Chair.
Before we come to you, I'll go to the Honorable Gishimo. Member for Gishogo. 142. Yeah, we are trying to trace you. We'll get you right now.
Thank you, Honorable Chair. I think I support the chair, since where a penalty, where an offense or where there is an offense, it has to be prescribed in the law, and there's no need of registrating in vain. And if there are offenses that may not be covered under the Act, then there will also be an opportunity by the CS to do regulations and provide for more penalties. So I believe he is in order to delete a provision that is already in the Act in vain.
Good. Honorable Zamzam.
I also want to support Mr. Chair, given that the penalty is also very harsh, 5 million and 5 years in jail. I think maybe we can replace with something that is reasonable. And maybe if you can get in the other laws, then we are good to go. We can delete it. Thank you, Madam Chair.
Thank you. The Honorable Dr. Mutunga.
Chair, bearing in mind that as Chairman has said, they were very thorough. They have looked through the bill intensively, and they are sure that all the penalties have been provided for. I think it will be an honor to delete.
Thank you very much. Then lastly, the Chair, can we proceed?
Madam Chair, we did take time. We burnt the midnight oil to give provisions for offenses that may occur. And in fact, the justification for the deletion of this is that, Madam Chair, a general penalty opens it up for so many opportunities for abuse. And it was the thinking of our committee that if there's another offense that is not thought of, it can live in a subsidiary regulation, not in the Mother Act, because the Mother Act does generally cover all foreseeable offenses. And if there was any of the nature that the professor is talking about, we believe that that can live in a subsidiary law. Thank you very much, Madam Chair, so that we do not legislate in vain.
The Honorable Mishimboko.
Yeah, Madam Chair, I was also with the opinion of what Honorable Undo has just said, because I've seen that although the penalties have been shown according to the specific provincial, but to me, Article 64 is like it's emphasizing on the penalty. So I don't know whether maybe we can do some arbitration between Honorable Chairman and Honorable Oundo so that we are at the middle to ensure that at least that emphasis in clause 64 is not just trashed, because I think it's also giving more sense on it, on that issue.
I wanted now to just put the question. So now then I give a chance to the Honorable Meli, who has not said anything on this bill.
Chair, I want to agree with the chair ICT, because if you look at what he's providing, if we are going to retain clause 64, it will be an overlap. And the specifications of the penalties have been actually provided for. So actually, Madam Speaker, I think the chair and the committee are right, and therefore we need to delete that clause. Thank you.
Yes, so yes, but after the Honorable Millie Othiambo. You will be the last, Honorable Chairman.
Thank you, Chair. Chair, I think if the committee has actually gone through and made provision for every single offense, then it is okay if you don't give an umbrella one. But that therefore means that you have actually gone through and you are sure that there is no offense that is provided, because you cannot also provide for an offense that is not in the bill. So I think I would support the chair on this.
Thank you. The Honorable Farah Maalim.
Chair, I also want to support the chair in this. This is too far-reaching, too open to abuse, and it's not something that you can just do it in the manner we have done right now in a generality and say any person who commits an offense. And basically, it can always be covered under the subsidiary law, which is going to be more exhaustive in my opinion.
Thank you very much. Chair, after all that support, do you still want to make a comment, or I go ahead and put the question?
Yes. Allow me so that we can carry the members along. It is actually for the reason that has been mentioned by the Honorable Zamzam and Honorable Mishimboko. You can see the general penalty was providing for a very steep penalty. And that what is unforeseeable could be something so trivial. And that is why, Madam Chair, if there was anything unforeseeable, I believe it can live in the subsidiary laws like the regulations, Madam Chair. I thank you and I move.
Thank you. I now put.
We clear in our own
Honorable
minds.
Maalim.
Yes, just so that we, because of the gravity of this kind of a matter and the consequences that are very, very severe, it's important that we give it as exhaustive engagement as possible. But already it says obstructs authority and says commits an offense shall be liable for. You've already prescribed. a penalty for that. And then you come in a very general one and say, is anybody who commits under this act? I think we should get away with it and just allow how the chairman has done the amendment on this one. We are going in a very dangerous direction.
Let's delete it.
Delete it.
I will go ahead.
Delete the whole of segment.
Honorable members, I now put the question that clause 64 be deleted as proposed by the chair. Be deleted as proposed by the chair. Will as many as have that opinion say aye? Aye. Will as many as have a contrary opinion say nay? The ayes have it.
Clauses 65, 66, and 67.
I propose the question that clause 65, 66, and 67 be part of the bill. There be no amendment. I now put the question that clause 65, 66, and 67 be part of the bill. Will as many as have that opinion say aye? Will as many as have a contrary opinion say nay? The ayes have it.
New clauses. New clause 21A.
I call upon the mover now to move second reading for this new clause.
Madam Chair, allow me, because this is a new clause, to read it in its entirety. I am proposing that the bill be amended by inserting the following new clause immediately after clause 21, and this is a clause on the Museum of Science and Technology in a Technopolis. Madam Chair, it should now read as 21A. The authority shall establish and manage a museum. Madam Chair, kindly protect me or provide for.
Point of order, Chair.
On the matter of the new clause?
Yes, just procedural matter. Okay. It's not really necessary for him to read the entire bill, because if we did that, then, Honorable Chair, we'll never finish legislation process. We are capable of reading, just mentioned as prescribed in the order paper.
You will paraphrase. What is out of order, Honorable Minority Whip? Honorable Millie Odhiambo.
Thank you, Chair. For me, it's two issues. One which is procedural, that when it's moving, it should actually first just indicate that I move that it be read a second time. Before then he explains. But secondly, even though it's a bit preemptive, I think because you want to set up a museum, I think the House has spoken to this issue, because that makes it a money bill. And I don't know if we are allowed to do that at this stage. Chair, maybe you can advise us on that.
They have gone through the office of the Speaker and they have been brought to the Committee of the Whole House. At this point in time, I would like to allow the Chair to proceed.
Madam Chair, the amendment here is to bring in this. And Madam Chair, I do propose that the bill be amended by inserting the new clause immediately after clause 21 as it is appearing on the order paper, Madam Chair.
Okay. I now propose the question that new clause 21A be now read a second time. Any interest in this? Honorable Oundo? Honorable?
Chair, I sincerely and heartily support, even though Minority Whip has raised a constitutional issue that rests somewhere else, but I sincerely support. And as I support, Honorable Speaker, I remember I was taken to a tour of Houston Space Museum in Texas, somewhere in the US, and I was mesmerized, truly mesmerized. And I just hope, it took me to science. But I would really see the way it is said, Honorable Chair, is at the discretion of the authority the authority may. Can we make, because again, in this house, I think we had a motion that called for the establishment of a science museum, which I think, if I'm not so sure it has been adopted or not, can we make it mandatory? Because May is discretionary, it might never happen or it might happen. I was just wondering, probably you had a good reason why you chose to use the word may instead of just establish.
Chairman, what is your comment on that?
Madam Chair, it is actually not may. And I know the wakilis here can tell us the difference between may and shall. Shall obligates, and may is as what Professor is saying. And the proposal, and that's why I was reading it, Madam Chair, but the proposal is that the authority shall establish and manage a museum of science and technology in a technopolis. So it is shall.
We need to confirm whether that is the position.
Reads may, unfortunately.
I'm going to give a chance to the chair to consult 2 minutes.
Yeah, please. The other paper reads may.
Is actually shall. So I wish it would reflect on the order paper as it is on the substantive one. It is. Huh?
So then I'll give you time for that to be corrected. 2 minutes.
Okay, let me.
You may proceed, Chairman.
Madam Chair, I thank you for the magnanimity. And thank you very much, members. And what I will do, Madam Chair, for us to be able to have a tidy process, allow me to move it as further amended so that it reads that the authority shall establish and manage a museum of science and technology in a technopolis. And in that way, it even covers what the Honorable Professor Undo is saying. Madam Chair, I propose to move as further amended.
Honorable Farah?
I want to concur with Honorable Millie Mabona. If it's definitely going to involve additional resources or resources for putting up that thing. And I think it's easy for anybody who is a busybody to contest that. And in any case, the shall itself on matters of developmental, which is a progressive thing, even if you put it shall, then determine when will that shall be. Is it immediately established, or 2 years down the line, or 3 years down the line? And I think, in my opinion, we have to amend it a bit further. If you want to retain the shall, then you have to say at the, you put certain appropriation, a certain appropriate. You must be conscious of the fact that those resources cannot be available instantaneously. And if you put it shall, so if you leave it to may, then of course it's there. You can put it in the programs and also in the development plan for this technopolis or polis. it is a money bill, but this is an additional.
Noted. I think you have made your point. Honorable members, I would like to appreciate that it takes a process for the bill to get where we are. And honorable members, I would like to take note of what the chair of the committee has said, and I'll go ahead and put the question. Honorable members, I put the question that clause 21 be amended as proposed be further amended as proposed by the chair. Will as many as have that opinion say aye? Will as many as have a contrary opinion say nay? There is have it. I now propose the question that clause 21A be part of the bill. Will as many as have that opinion say aye? Will as many as have a contrary opinion say nay? There is have it.
New clause 68.
I now call upon the chair to move the second reading.
Madam Chair, I move that clause 68 now appear as further amended. Madam Chair, I do move.
68, right?
Madam Chair,
the second reading.
Yes, I do move that clause 68 be amended as appear in the bill.
Be read a second time, Chair.
Madam Chair, I do move that clause 68 be read a second time.
I propose the question that new clause 68 be now read a second time. Will as many as have that opinion say aye? Will as many as have a contrary opinion say nay? There is have it. I now propose the question that new clause 68 be part of the bill. Will as many as have that opinion say aye? Will as many as have a contrary opinion say nay? There is have it.
Schedules, first and second schedule.
I propose the question that the first and the second schedule be the schedule of the bill. Will as many as have that opinion say aye? Will as many as have a contrary opinion say nay? There is have it. I now put the question that first and second schedule be the schedule of the bill. Will as many as have that opinion say aye? Will as many as have a contrary opinion say nay? There is have it.
Clause 2.
I propose the question that clause 2 be part of the bill. Chairman, you have an amendment.
Madam Chair, I'm moving to amend clause 2 as is appearing on the order paper. And why we are doing this, Madam Chair, is because the Technopolis bill will also be establishing a science museum, and therefore it is important to define the term museum. The amendment seeks to provide for the establishment of a science museum in a Technopolis, and the science museum will serve as a hub and an interactive space where Kenyans can appreciate the advancements in science and technology. The museum will also provide an avenue for recognizing the role of science and indigenous technologies, Madam Chair, and Kenya's contribution, and indeed Africa's contribution to the development of science, technology, and innovation. Madam Chair, I do move.
Thank you. I propose the question that clause 2 be amended as proposed by the chair. Honorable Wilberforce Oundo.
Chair, I'm not so sure the definition of Technopolis, especially the last part that says and includes the Konza Technopolis. I thought Konza Technopolis, just like any Technopolis, would apply to be registered as Technopolis. Why are you, from the very first instance, safeguarding or protecting in the act? Would you just leave it? And I hear very tough words here, sophisticated, cutting edge. Good.
Chairman?
Madam Chair, there is very good reason why we are doing this. Is because while this bill seeks to set up many more technopolises around the country, Konza Technopolis already exists, and it also exists under the Konza Technopolis Development Authority. which we are retiring with this bill, so that Konza Technopolis does not hang nowhere. It is why the Konza Technopolis is singled out and mentioned in this instance. Thank you very much, Madam Chair.
So, honorable members, I proceed to put the question. I now put the question that clause 2 be amended as proposed by the chair. Will as many as have that opinion say aye? Aye. Will as many as have a contrary opinion say nay? There is have it. I now put the question that clause 2 as amended be part of the bill. Will as many as are of that opinion say aye? Aye. Will as many as have a contrary opinion say nay? There is have it.
Title.
I propose the question that the long title be the title of the bill. Chairman?
Madam Chair, I'm rising to propose that the long title of this bill be amended by inserting the word establishment immediately after the words a framework for the. And the reason for this, Madam Chair, is because this addition of the word establishment in the long title of the bill seeks to enhance the clarity that the bill seeks to guide on the establishment of technopolises. Thank you very much, Madam Chair.
Thank you. I put the question that the long title be amended as proposed by the chair. I now put the question. I now put the question that the long title be amended as proposed by the chair. Will as many as have that opinion say aye? Aye. Will as many as have a contrary opinion say nay? The ayes have it. I now put the question that the long title as amended be part of the bill. Will as many as have that opinion say aye? Aye. Will as many as have a contrary opinion say nay? The ayes have it.
Clause 1.
I propose the question that clause 1 be part of the bill. And there be no amendment, I now put the question that clause 1 be part of the bill. Will as many as are of that opinion say aye? Will as many as have a contrary opinion say nay? The ayes have it. Now I would like honorable members to call upon the mover.
Thank you very much, Honorable Speaker. Honorable Speaker, Honorable Chairperson, I beg to move that the committee do report to the House its consideration of the Technopolis Bill, the National Assembly Bill number 6 of 2024, and its approval thereof with amendments.
I put the question, which is that the committee do report to the House its consideration of the Technopolis Bill, National Assembly Bill number 6 of 2024, and its approval thereof with amendments. Will as many as have that opinion say aye? Aye. Will as many as have a contrary opinion say nay? The ayes have it. Honorable members, now we have finished the Technopolis Bill, National Assembly Bill number 6 of 2024. And we are now going to move to the Coffee Bill, Senate Bill number 10 of 2023.